Good afternoon, everyone. Anjali, are you there?
Start?
Anjali?
So shall we start?
Yeah, shall we start?
Good afternoon, everyone. I welcome you all to the webinar series 6 on anatomy of cases. Today's session will be taken by Nilesh Sharma, sir. Let me briefly introduce sir. Sir is a first partner in Triple R Insolvency Service Experts LLP. He is a practicing insolvency professional since the notification of IBC. He is graduate in commerce, graduate in law, chartered accountant, and sir is practicing in area of restructuring and insolvency for over 35 years. For over 25 years. He has been representing number of clients before different benches of NCLT and CLET on regular basis and providing strategy, advisory and consultancy to large number of industrial groups on debt restructuring within and outside CDR mechanism, negotiating settlements, etc. Sir is member of Insol India, an association of practitioners in insolvency law having international affiliation. His articles on restructuring and insolvency have been published in various national and international law journals. Sir is rated as one of the leading lawyers in the field of restructuring and insolvency by various reputed international journals like Legal 500, Chambers and Partners, Asia Law Profiles, etc. for many years. Now I will request sir to take up the session, please.
Okay, thank you, Anjali. Thank you. And good afternoon, everyone. Let me, I think we are already late. Let me start with my sharing of my PPT with you. 1 minute, please. Hope you can see it on your screen, please.
Yes, sir, we can see it.
Okay, okay. So anatomy of IBC case laws. So what I have done is, I think certain judgments have been incorporated in this PPT. Let's see how many of them we can cover today. Let me start with this judgment, which is Srimati Sudeepa Nath versus Union of India. And kindly mute yourself, huh? Yeah. So this is a judgment which has been delivered by Honorable Tripura High Court, and this is mainly relating to Section 66 of IBC. So, and then this particular judgment, with respect to this particular judgment, there is another Honorable Supreme Court judgment wherein they have confirmed the findings or the judgment which has been made by Honorable Tripura High Court. So let's start. Facts of the case. So petitioner filed an application. It is echoing, I think. Hello. Yeah. So petitioner filed application under Article 226 of Constitution of India for issuance of a writ of mandamus or in the nature thereof, to issue appropriate orders or directions directing the respondent to forthwith take steps to declare section 66(1) of IBC as ultra vires on the wise of Article 14 of Constitution of India. So the prayer here was to declare section 66(1) of IBC as ultra vires. And reason for the same, that it is violative of Article 14 of Constitution of India, for being manifestly arbitrary and unconstitutional, or to save it from unconstitutionality, and in consonance with the scheme and object of IBC, scope thereof is enlarged by this honorable court by expanding the powers and jurisdiction of NCLT. So prayer here was in this writ petition. This was a writ petition which was filed before Honorable Tripura High Court under Article 226. So you are aware that writ petitions are filed under Article 226 of Constitution before different high courts and before Honorable Supreme Court under Article 32. So here under Article 226, this writ petition was filed, and the prayer was that 66(1), section 66 subsection 1 is violative of Article 14 and is therefore unconstitutional. So it should be set aside or deleted. So, and what were the they said, if you don't want to delete these provisions, then in that case you extend the powers of the board. You make changes to IBC. You direct central government to make certain changes to IBC. Okay, and what were those changes? One, by enabling it to declare fraudulent business transactions as void under section 66, independent of section 43, 45, 47, 49, and 50. One very, very important thing which has been upheld in this particular judgment is that section 66, under section 66, NCLT is not having the power to set aside a particular transaction. So you must have seen that under section 43, 45 and other sections which have been listed, there NCLT is having the powers to avoid that transaction, or to direct that this transaction was null and void, and to direct that money which has been given, that should come back from the third parties, or suppose some charge has been created, so they will say that this transaction is cancelled. Okay, so those transactions, those directions are avoiding these powers under these sections, other sections, not under section 66, 43, 45, 47, 49, and 50. Under those sections, powers are with the adjudicating authority, which is NCLT, to avoid certain transactions, to avoid certain fraudulent transactions. That's why we say that we are filing avoidance application, so that we request honorable adjudicating authority to direct that these transactions are avoided because these were fraudulent in nature. Okay, so 43, 45, etc., there the powers are with the adjudicating authority, but under section 66 this power is not there. Okay, so this here honorable Supreme Court, the honorable Tripura High Court was requested or prayed that either you declare this subsection 1 as violative of Article 14, delete it, or otherwise what you do is, if you want to save it from unconstitutionality, then in consonance with the scheme and object of IBC, scope thereof is enlarged by this honorable court by expanding the powers and jurisdiction of NCLT. They said that if you don't want it to be declared as unconstitutional, then in that case you expand the powers and jurisdiction of NCLT by enabling NCLT that they can declare the fraudulent transactions under section 66 as void. Okay, which is not there presently. At the most, what they can do is honorable adjudicating authority can direct the persons who were there in the management and who were responsible for these fraudulent transactions to contribute some money to the assets of the corporate debtor. Okay, so but this power to avoid transaction is not there. Then they said, so this is not the only prayer. The other prayers are that if you don't want it to be declared as unconstitutional, you want it to be saved from unconstitutionality, then what you can do is by enabling it to entertain applications under section 66(1) on its merits, even if filed by any creditor or contributory of the CD. Okay, so at section 66 presently says that application can be filed by the resolution professional only. Okay, there is some defect in the language also. We will see the language. We'll see what is written there under section 66, and then we will find that yes, there is some anomaly in the language. Okay, so for that reason, they are saying, on the one hand, it says that the application under section 66 can be filed during CIRP or during liquidation. And then it says that application can be filed by resolution professional only. So if the company is under liquidation, then RP is not there, then there is liquidator. Okay, so this anomaly is there. We'll discuss about that. So, but other than these two, RP or the liquidator, these are the only persons who can file this application for seeking directions under section 66. Other parties, whether any creditor can file it, whether any shareholder can file it, answer is no. So this application under section 66 can be filed only by the RP, or if it is under liquidation, by the liquidator. But here he said the applicants requested, or the petitioner requested, that kindly allow the creditors or other contributories also. Contributories are who will be contributing in the assets of the company, or in other words, the shareholders. So creditor or contributory of the CD to also file this application. They should also be allowed to file this application. And reason for the same is that under Companies Act, so you are aware that under Companies Act, winding up of a company can take place for the reasons other than due to insolvency. If liquidation is there because of insolvency situation, where a creditor is not able to, where a debtor is not able to pay its dues in the ordinary course of the business, then in that case, the liquidation will take place under the provisions of IBC. But there are a number of other reasons also, for which also a company can be liquidated or wound up. So for that purpose, powers are contained, or the provisions are contained under the Companies Act, not under the IBC. So the corresponding, there also similar provisions are there. There also provisions are that if you are giving any preferential payment, then that can be set aside. If there is any undervalued transaction, then also there are provisions under Companies Act, because there also, so for two different reasons, liquidation is taking place. So when it is for the reason that company is insolvent, then it will be under IBC. But for other reasons, so if it is being wound up for other reasons, then in that case also similar provisions will apply. So that does not mean that they cannot, if they have siphoned away money, so that cannot be brought back. So similar provisions are there under Companies Act also. And the creditor or contributory is also allowed in section 339 of Companies Act 2013. So here the petitioner requested that in the Companies Act, this creditor or contributory can file this application, similar type of application. Then why can't you do that why don't you allow them, the creditors and contributory, to file this application under 66? If for any reason the liquidator or RP does not do that, then the creditor or contributories, they should be allowed. Okay. Then further, by expanding the powers and jurisdiction of NCLT, by enabling it to pass an order, making liable to make such contribution to the assets of the CD as it may deem fit, not only against any persons who are knowingly parties to the carrying on of the business of the CD in such manner, but also against other organizations, legal entities other than CD. So presently, if you see section 66, so section 66 says that those people who were like the people who are there in the management or against any person who are knowingly parties to the carrying on of the business of the CD in a fraudulent manner. Okay, so only those can be proceeded against. So here third prayer is that the adjudicating authority, there should be change in this section 66(1), which should now allow the adjudicating authority to proceed against other entities also. So not only against those who are there in the management, of the company when fraudulently business was being carried on, but also against third parties. So this was another prayer, and not only against the legal entities or organization, not only against a company. Suppose with some third company, another company, there was a fraudulent transaction. So not only against the company, the adjudicating authority should be allowed to proceed against those who are there in the management, of that company at that particular point of time. So these were two additional prayers, that not only against those who are knowingly parties to the carrying on of the business of the CD in such manner, which is there presently in section 66, but also against other organizations, legal entities other than the CD with whom such business was carried on, but also against any person responsible for carrying on the business with CD in such organizations or legal entities. So those people who were there in the management of those entities with which fraudulent transactions have taken place, against them also 66 power should be granted to adjudicating authority. So these were the main prayers. Then to issue directions to the respondent, which is Government of India, Union of India, to consider introducing appropriate amendments in section 66(1) of IBC, expanding the powers and jurisdiction of NCLT. Okay. So one, that you expand the scope of this section, or otherwise you issue directions to Union of India to consider introducing an appropriate amendment. So the Union of India should make changes to section 66(1) of IBC, expanding these powers of NCLT. So again, let's see. One, to declare fraudulent transaction as void, which is not the power presently. Then the application should be allowed to be filed by creditor or any contributory, not only by the liquidator or resolution professional. Then third is that the NCLT should be allowed to proceed in these transactions against third parties and the management of the third parties entities. So these were the prayers in this particular writ petition. Then what were the arguments which were given, which were made by the petitioner? Petitioner contended the fraud of gigantic proportions are being played by the corporates to defraud the gullible creditors to siphon off public money. He contended that introduction of IBC is in public interest. According to him, grant of prayers made by him would serve public interest and would enable maximum recoveries under IBC for the creditors of a corporate debtor. Okay. So he said that it is in public interest, and these powers, if these powers are granted to the adjudicating authority, then in that case better recovery will be there for the creditors. Then petitioner further submitted that although broadly section 339(1) of Companies Act 2013 and section 542 of Companies Act 1956. So 540 is similar to section 339, which is there under Companies Act 2013, may appear to be pari materia to section 66(1). So pari materia is similar to section 66(1). There is clear distinction in the application of the provisions and the scheme under the Companies Act vis-a-vis IBC. He says, though these provisions are similar, however, under section 66, certain 66 and these sections, differences are there. Clear distinction is there, which should not be there. Why different provisions are there under these? These provisions are there to tackle a particular kind of situation. So similar power should be there with the authority, with the adjudicating authority, while they are dealing with section 339 or 542, or when they are dealing with section 66(1). So this was his contention. It was further submitted that there is urgent need of passing appropriate directions as prayed for by him in the interest of justice. The prayers, if granted, would strengthen the framework for insolvency and bankruptcy. So these were his main prayers. Then Honorable High Court. Decision by Honorable High Court. Before that, I think, okay, we'll see the section 66 subsequently, or we can see that now also. Let me share that with you before I think we proceed further with this judgment. So can you see that section 66?
Yes, you can see that.
Yes. So fraudulent trading or wrongful trading. So fraudulent trading or wrongful trading, actually these two terms are having a meaning which normally we are having the impression that all fraudulent transactions are covered here. Actually, 43 is also a fraudulent transaction. 43 is what? You are giving a preference to a particular creditor. So you are committing a fraud with other creditors. You are making payment to a particular creditor at the cost of others. So that is a fraud. That is a kind of fraud. 45 is also a fraud. 45 is undervalued transaction. So what you are doing is that you are selling some asset of the company or some goods of the company at a consideration which is less than the market value. So that is also a kind of fraud. Okay, and then other sections are also there, 49 and then 50 and others. So there also frauds are there. But here the meaning, what is the meaning of fraudulent trading or wrongful trading? Actually, this the wrongful trading word has been taken from UK's law. Their wrongful trading is if you know, if the management of a company know that the company is not able to pay its dues, that means, in other words, it has become an insolvent entity. So they say that at that point of time or after that point of time, you should not continue with your business. The existing management should not continue with its business. And reason for the same is that if you know that you can't make payment of the dues of existing creditors and still you are carrying on business, that means you will be purchasing further material, you will be availing further services, and knowing fully well that you will not be able to pay their dues. If some supplier is supplying you some goods, you are not able to pay you the dues of your existing suppliers. So what, you are going to some new supplier and then you are asking him to make the supply, though you know that you can't make payment to him. Then in that case, what is that? That is a kind of fraud. You are continuing with your employees, telling them that, okay, we'll pay. And your employees, they are providing you services. And you know that you will not be able to pay their dues. Still, you are continuing their employment. So that is what? That is a fraudulent transaction. That is a fraudulent continuation of business. So if you know that you will not be able to continue, you will not be able to pay the dues of your suppliers or creditors, then in that case, you are not entitled to carry on your business. So if you still carry on your business, that will be called wrongful trading, or in other words, fraudulent trading. Okay, so actually 66 intention is that only. And that is the reason that management has been made responsible. They say that if you still continue with your business, you know that you are not in a position to continue with, you are not in a position to pay the dues of your creditor, and still you are continuing, then you can be made liable. Okay, so whatever loss happens after you have come to know that company has become insolvent, so the director or the management, they can be held liable for the loss which is caused to the company during this period. Okay, so if as insolvency professional, we have come to know that the company committed a default 2 years back or 3 years back, and the management has not made the reference under section 10. Actually, it is mandatory for them to make an application under section 10. And if they don't do that, then in that case, they can be held liable. And I think when you file an application before adjudicating authority for the purpose of section 43, 45, etc., then in your application under section 66, you must hold them liable for the losses which have been caused during this period. Let them explain to honorable adjudicating authority that they have taken reasonable steps to avoid incurring these losses. But it is our duty that this was the period of wrongful trading. They did not file application, and if application has been filed under section 10, and after that adjudicating authority is not accepting them, if they are taking time, then you can't hold them responsible, you can't hold management responsible, because management has taken the steps. Okay, one of referring the matter to adjudicating authority, and then in addition they may be taking some other steps also. Okay, so wrongful trading or fraudulent trading is actually this thing. And another thing, I think most of the time I discuss this particular thing, that the insolvency, as we all know, that insolvency can be of two kinds. Insolvency definition, which we have adopted, is based on cash flow based insolvency. There can be another definition of insolvency, which can be net worth based insolvency or balance sheet based insolvency. Net worth based or balance sheet based insolvency is where the liabilities of a company are more than the assets. Okay, so where liabilities are more than the assets, so that is balance sheet based insolvency or net worth based insolvency. The insolvency definition which we have adopted is cash flow based insolvency. So we may be having, the company may be having asset worth rupees, for example, 100 crore, but its liabilities are only 40 crore. But still, because asset is an industrial asset, he is trying to sell it, but he is not able to sell it, and he has become a defaulter. So though assets are there, value of asset is more than the liabilities, but still there is a default. So our definition is default based definition, where we don't consider how much is your net worth. We don't consider how much is your value of your asset. If you have defaulted to your creditors and amount of default is more than 1 crore, then you become an insolvent entity. And then against you, insolvency proceedings can be initiated by you, by the creditors. And if you have committed this default, then in that case, it is mandatory for you. Otherwise, you can be held personally liable to make good the losses. Okay. And that balance sheet based definition used to be there earlier in our earlier law, which was Sikh Industrial Companies Act. So you are aware that under Sikh Industrial Companies Act, that was limited to only industrial companies. And under that law, the definition was that if your accumulated losses are more than your net worth. So if your net worth is promoter, they have brought in equity and the profits which have been earned from time to time, that is, for example, 60 crore, and you have incurred losses of more than 60 crore. Suppose your losses are 100 crore. That means what? That means you have whatever share capital or reserves were there to the extent of 60 crore. You have lost that already, and you are having further losses to the extent of 40 crore. And who has funded these losses? Creditors. So once your net worth is fully eroded, if you are still carrying on your business, then you are carrying on your business at the capital which is provided, on the capital which has been provided by your creditors. So your capital is not there, which is actually there should be some capital of the equity shareholders or the promoters. Okay, so that was the earlier definition, which was under Sikh Industrial Companies Act. But now under IBC, we are not having that definition, and that definition is based on default. Okay, so if there is a default and we are not filing this one, so then this fraudulent trading or wrongful trading thing, these terms will apply. Let's go through this provision of 66(1). If during the CIRP or a liquidation process, it is, and kindly see here, during CIRP or liquidation process, so under both the processes, not under only CIRP, if during CIRP or a liquidation process, it is found that any business of the CD has been carried on with the intent to defraud creditors of the CD or for any fraudulent purpose, the adjudicating authority may, on the application of the RP, but application of the RP, if it is under liquidation, then RP cannot make that application. How he will be making that application? So actually the word should be on an application by the RP or by the liquidator, because the starting words are, if during CIRP or liquidation process, it is found that any business of the CD has been carried on with the intent to defraud creditors of the CD or for any fraudulent purpose, the adjudicating authority may, on the application of the RP, pass an order that any person who were knowingly parties to the carrying on of the business in such manner shall be liable to make such contribution to the assets of the CD as it may deem fit. Okay, so if you are carrying on the business, then those persons who are knowingly parties to the carrying on of the business on fraudulent purpose, then they can be asked to make such contribution to the assets as it may deem fit. So power has been given to adjudicating authority. Adjudicating authority will decide as to how much amount they have to contribute to the assets of the CD as it may deem fit. And how adjudicating authority will decide? So I think adjudicating authority has to decide. They have to estimate as to how much loss has been incurred during this period where this fraudulent conduct of business was there. Okay. 2, subsection 2. On an application made by a RP, again, RP only, application made by a RP during the CIRP process, the adjudicating authority may by an order direct that a director or partner of the CD, as the case may be, shall be liable to make such contribution to the assets of the CD as it may deem fit, if then there are certain conditions. So here also it says application by the RP, not by liquidator, but initial words are that if during insolvency, CIRP or liquidation. So it appears that I think there is an anomaly, but intention is that during liquidation also, if you have come across any such situation, then you have to bring it to the notice of adjudicating authority, who will pass appropriate order. On an application made by RP during the CIRP, the adjudicating authority may by an order direct that a director or partner of the CD, as the case may be, shall be liable to make such contribution to the asset of the CD as it may deem fit. Another thing is only RP here. It says only RP. If RP fails, then whether creditors can do that, whether shareholders can do that, answer is no. Then if, so what are the conditions? Before the insolvency commencement date, such director or partner knew or ought to have known that there was no reasonable prospect of avoiding the commencement of CIRP in respect of such corporate debtor. So if you knew that CIRP has to be made, that means you were knowing that CIRP cannot be avoided. Even then you were continuing with the business. B, such director or partner did not exercise due diligence in minimizing the potential loss to the creditors of the corporate debtor. Okay, so what is expected from him? They did not exercise due diligence in minimizing the potential loss. Okay, so this is to be decided by honorable adjudicating authority. And I think one such step he should have taken was that he should have made the reference application under section 10. Okay, then subsection 3. Notwithstanding anything contained in this section, no applications shall be filed by a RP under subsection 2 in respect of such default. This is section 10. I think we can ignore that. So these are the two sections, subsections 66 and 66.1 and 66.2, where it says that RP can do it, and then this action can be taken against whom? Subsection 2 says that against director or the partner, and subsection 1 says those people who are knowingly parties to the carrying on of the business. It does not say that transactions entered into with third parties can be set aside. It does not say that those transactions can be reversed. Okay, so for that particular purpose only, the application, this writ petition was filed by the petitioner, and he said or she said that these changes should be made in section 66. That, and what were the changes? It said that the not only the RP, but liquidator and creditors and the contributories or shareholders, they should also be allowed to file this application for any reason if RP does not file that. Then the NCLT should be given the power to avoid these transactions. So if under section 66 there is some transaction which is noticed that it is for fraudulent purpose, then adjudicating authority should declare that transaction as avoidable transaction, or they direct for avoidance of that transaction, like 43-45, and then to proceed against the third parties also, not only against the guarantors and not only against the director and promoter. Okay, against third parties also. If suppose you have supplied material to a third party, okay, and which is as a result the company has suffered loss. So I think the intention here is of the petitioner that in that type of a situation, if third party has been benefited because of a fraudulent conduct, then that third party recovery should be made from the third party. That power should be there with the adjudicating authority. So these were the prayers. That this 66 should be changed. Amendment should be made there. Let's go back to our PPT. Yes. Decision by Honorable High Court. So after hearing the arguments, after hearing the justification which was given, so Honorable Tripura High Court said, let's read the same. Honorable High Court noted that under the Companies Act 2013 or 1956, the application under section 339(1) or section 542, as the case may be, would be filed only in the case of winding up of company. However, an application under section 66(1) can be filed during CIRP process or a liquidation process. So as you know that under the Companies Act, this CIRP process is not there before initiating any winding up or liquidation. Okay, so this IBC, under IBC only, we are having this CIRP process. So Honorable High Court said that under the Companies Act, under these two sections, the application can be filed during the course of winding up, and under IBC, this can be filed under even not only under liquidation, but also under CIRP. CIRP having been introduced, laid down by wide IBC, the legislature has consciously extended the application of provisions even to the matters during CIRP, instead of restricting it during the liquidation process. It relied on various judgments and held that Section 339 of Companies Act 2013 or pari materia provisions of Section 542 of Companies Act 1956 were aimed at conferring jurisdiction in the courts of winding up of a company to proceed against the persons responsible for fraudulent conduct of the business of the company. Okay, so here I think better will be, let's see a comparison of these sections 339, 540, 542 and 66. They are the word which has been used is pari materia. So that means similar, they are similar. Okay, so let's see that also. So in this judgment of Honorable Tripura High Court, there has been a comparison. This one. Section 542 of Companies Act 1956. And then next is Section 339(1) of Companies Act 2013. And then we are having 66(1) of IBC. So if you compare the language, so language is very, very similar. Let's see. So first we compare 542 with 339. 542, liability for fraudulent conduct of business. 339 also says liability for fraudulent conduct of business. And 66 is fraudulent trading or wrongful trading. Okay. Then 542(1). If in the course of the winding up of a company, it appears that any business of the company has been carried on. And if you see this one, 339, also languages, if in the course of the winding up of a company, it appears that any business of the company has been carried on with intent to defraud creditors of the company or any other person or for any fraudulent purpose. And if you see the language there also, but slight differences there, 66, if during the CIRP or a liquidation process, because CIRP process is not there under Companies Act. So under IBC it is there. So 66, though these are comparable sections with each other, but CIRP under 66, there is this added words which are, if during the CIRP or a liquidation process, and then compare it is found that any business of the corporate debtor has been carried on with intent to defraud creditors of the CD or for any fraudulent purpose. The language here is similar till here. Then let's come back to these other two sections. The court, so left one, this is section 542 of 1956. 542 says, the court on the application of official liquidator or the liquidator or any creditor or contributory. So this difference is there. Here our 66 says that the adjudicating authority of the fraudulent purpose, I think there is something missing. Resolution professional on the application of the resolution process pass an order. But here not only the liquidator, the creditor, any creditor or contributory can also file an application before adjudicating authority. Then Mr. Naresh, kindly mute yourself. Mr. Naresh. Naresh, kindly mute yourself.
Yes, sir.
Yes. Okay. So this was the request in this writ petition, that why under 66 you are writing that only RP can do that. You allow others also, you allow creditor and contributory also, which is there under these two sections of Companies Act 1956 also and 2013 also. Then further, if it thinks it proper so to do, declare that any persons who are knowingly parties to the carrying on of the business in the manner aforesaid shall be personally responsible without any limitation of liability for all or any of the debts of other liabilities of the company as the court may direct. And here further 339, on the application of the official liquidator or any creditor or contributory of the company may, if it thinks it proper so to do, declare that any person who is or has been a director, manager or officer of the company or any persons who are knowingly parties to the carrying on of the business. So here the 1956 Act says that any persons who are knowingly parties to the carrying on of the business in the fraudulent manner. But here 2013 says that any person who is or has been a director, manager or officer of the company or any persons who are knowingly parties to the carrying on of the business in the manner aforesaid. Here also it does not say third parties are included. Whether you can proceed against third parties, answer is no. Whether you can set aside that transaction, answer is no, because here they say that the powers are that adjudicating authority will hold these people liable, that if it thinks it proper so to do, declare that any person who is or has been a director, manager or officer of the company or any persons who are knowingly parties to the carrying on of the business in the manner aforesaid shall be personally responsible without any limitation of liability for all or any of the debts or other liabilities of the company as the tribunal may direct. So they are holding them liable, these people who are parties to these transactions. So they were made liable for meeting the liabilities towards the liabilities of the company for without any limitation. Okay, so this was the language under these two sections. Then in our 66 now, during the CIRP or liquidation process, it is found that any business of the CD has been carried on with intent to defraud creditors of the CD or for any fraudulent purpose. The adjudicating authority on the application of the resolution professional pass an order that any persons who are knowingly parties to the carrying on of the business in such manner shall be liable to make such contribution to assets of the corporate debtor as it may deem fit. Okay, so the difference is that any of these parties, creditors and contributories, they can also file this thing. And rest of the provisions are that there they say that he can be held liable for any of the debt of the company. Here also they can be held liable, though the section does not say very clearly that, but it says the amount as may be deemed fit by the adjudicating authority. And adjudicating authority in all the cases will adopt the same method. They will estimate as to how much loss has taken place during this period. So let's go back to our presentation. It relied on various judgments and held that we are talking about honorable judgment of Honorable Tripura High Court. It relied on various judgments and held that Section 339 of Companies Act 2013 and pari materia provisions of Section 542 of Companies Act 1956 were aimed at conferring jurisdiction in the courts of winding up of company to proceed against the person responsible for fraudulent conduct of the business of the company. Both these provisions were aimed at making such persons personally liable for such fraudulent trading, to recouping losses incurred thereby, and to relieve the company for the liabilities incurred by fraudulent trading. Then Section 66(1) also directed towards making such persons personally liable for such fraudulent trading, to the recouping of losses incurred thereby, and to provide that NCLT can pass order holding such persons liable to make such contributions to the assets of the corporate debtor as it may deem fit. So now Honorable High Court is saying that these provisions are pari materia. Okay, no power has been conferred on NCLT to pass such orders against other organizations, legal entities other than corporate debtors, with whom such business was carried out, against any person responsible in such other organization, legal entities for carrying on business with corporate debtors. So Honorable High Court said that against third party or the management of the third party, these powers are not there with the NCLT. Any application under section 66(1) will have no effect on legality or validity of an independent criminal action in accordance with law against such organizations, legal entities, and persons responsible for conduct of their business with corporate debtor. So Honorable High Court said that NCLT is not having the power under section 66 to avoid the transaction or to proceed against third party entities or their management. But at the same time, RP is free. RP, liquidator, or suppose there is a resolution plan approved, then in that case, the new management is entitled to proceed against the debtors or to proceed against those parties with whom these fraudulent transactions have taken place. But NCLT cannot pass order. If so, now what we have to do as RPs, what we are doing is that in applications which we file with Honorable Adjudicating Authority under section 66, we include all fraudulent transactions and everything. Though actually those are not included there, but still, if suppose you are filing that application, then your prayer can be that you will be requesting or praying the Adjudicating Authority to issue directions to those who are there in the management of the company, in the management of the CD, at appropriate point of time to contribute to the assets of the company. If loss has taken place in the company because of these people, suppose 20 crore of rupees has been the loss during this period, and CD has suffered this much of loss because of the fraudulent conduct of these people who are there in the management, then in that case, our prayer should be that issue directions to these people who are there in the management at appropriate point of time to contribute to the assets of the company. We must also try to estimate the loss, that this much of loss has been caused due to these people. Now, we should not write that this transaction should be avoided, this transaction should be set aside, the third party should be asked to refund the money, or that type of thing. You can't request Adjudicating Authority because under section 66 power is not there. So if you want to proceed against the third parties, you must take action against those. So then what action is to be taken? You have to file recovery suit against them. You should initiate, if any criminal action is there, you initiate some criminal action against them. Okay. If these are companies, you want to initiate CIRP process against them, then file an application for initiation of CIRP. Okay. So it is not, till now what we were doing was that we were filing application with Adjudicating Authority, and we were requesting Honorable Adjudicating Authority to make the recovery on our behalf from third parties. So which is not possible now. Okay. Then Honorable Adjudicating Authority then held that there is no arbitrariness, matchless manifest arbitrariness in section 66(1) of IBC to entertain the instant petition to declare the said provisions as ultra vires of Article 14 and unconstitutional as alleged or otherwise. So final decision is this. So there is some elaboration of this as to what has been said by Honorable High Court. Under the Companies Act 2013 of 1956, application under section 339 or section 542, as the case may be, would be filed only in the course of winding up of company. However, an application under section 66(1) can be filed during CIRP or a liquidation process, CIRP having been introduced laid down by the IBC, the legislature has consciously extended the application of provisions even to the matters during CIRP instead of restricting it during the liquidation process. In all these three provisions, the common mandatory prerequisite satisfaction is that if any business of the CD has been either carried on, one, with the intent to defraud creditors of the company oblique corporate debtor, or for any fraudulent purpose. So these are the two requirements under all these three sections. Under the Companies Act, the application filed by the official liquidator or the liquidator or any creditor or contributory of the company could be entertained. Okay, so under those two sections, creditor or contributory can also file applications. However, under section 66(1) of IBC, only an application filed by RP can be entertained by NCLT, rather by liquidator also. All the three provisions are aimed at fixing the liability of persons responsible for such conduct of business of the company oblique corporate debtor, which is with fraudulent purpose and a required mens rea. That means in all these three sections, there should be a fraudulent purpose. There should be a mens rea, intent to defraud should be there. Okay, in all these three sections, because the language which has been used is that yes, there should be the act should be with fraudulent motive. Under the Companies Act, the provision empowers the court oblique tribunal to hold such person personally responsible without any limitation of liability for all or any of the debts or any other liability of the company as the court may direct. So this is under Companies Act. However, under section 66(1) of IBC, NCLT can pass an order holding such persons liable to make contribution to the assets of the CD as it may deem fit, which we have already discussed. Then, legislature has carefully made this distinction in section 66(1) of IBC that this section may also apply during CIRP and need not be only during liquidation. So it very clearly says that RP will do it, and then it says that during CIRP or liquidation. If no resolution plan is received under IBC or in any event in the event which is prescribed under IBC, corporate debtor would be subject to liquidation and the assets of CD would be distributed amongst the creditors in the manner provided in IBC. Section 339 of Companies Act 2013 and pari materia provisions of section 542 of Companies Act were aimed at conferring jurisdiction in the course of winding up of company to, I don't know whether there is a repetition. 9. Okay. Were aimed at conferring jurisdiction in the course of winding up of the company to proceed against the persons responsible for fraudulent conduct of the business of the company. Both these provisions were aimed at making such persons personally liable for such fraudulent trading, to recouping losses incurred thereby, and to relieve the company of the liabilities incurred by fraudulent trading. The said directions cannot, however, be passed against third parties. So this is important finding of Honorable High Court. Section 66(1) is also directed towards making such persons personally liable for such fraudulent trading, to recouping losses incurred thereby, and to provide that NCLT can pass order holding such persons as liable to make such contribution to the assets of the corporate debtor as it may deem fit. No power has been conferred on NCLT as such order against other organizations or legal entities other than CD with whom such business was carried on. Business was carried out, or against any person responsible in any such other organizations, legal entities for carrying on business with corporate debtor. For the said purpose, ratio of judgment of Honorable Supreme Court in Usha Ananta Subramaniam in the context of section 339(1) of the Companies Act would clearly apply, even in the context of section 66(1) of IBC. So Honorable High Court said that Supreme Court, so there is a judgment of Honorable Supreme Court in the matter of Usha Ananta Subramaniam, wherein Honorable Supreme Court said that under section 339, So you are aware that Usha Ananta Subramaniam was the I think she was the CMD of Punjab National Bank at some point of time, and there was a matter. I think that matter was relating to that jeweler. I don't remember the name. Very famous case. So in that particular case, the recovery proceedings were initiated against the MD of this particular bank, and honorable under section 339, that there was a fraud which was conducted by that entity, and they said that these parties were also involved in that fraudulent conduct. Okay, so on that basis, their personal assets were attached. So under section 339, because that was not under IBC, so Honorable Supreme Court said that under section 339, there is no power to attach the assets of third parties or third entities. So this was the judgment of Honorable Supreme Court in Usha Ananta Subramaniam case. So, Honorable High Court, Honorable Tripura High Court in this particular matter said the same judgment will apply here also. This judgment will apply to section 66(1) also, because section 66(1) also does not empower adjudicating authority to proceed against third parties. Then, accordingly, an application under section 66(1) by the RP would not bar any civil action in accordance with law, either at the instance of RP or liquidator, or by the corporate debtor in its new avatar on a successful CIRP for recovery of any dues payable to the corporate debtor by such organization, legal entities. So third parties, Honorable High Court said that you can proceed against the third parties, RP can proceed against the third party, liquidator can proceed against the third party, or if resolution plan is already approved, then the resolution applicant, successful resolution applicant, can also file a recovery suit for that amount, but not under section 66. Such legal action is independent of section 66(1). Similarly, an application under section 66(1) will have no effect on legality or validity of any independent criminal action in accordance with law. So you can proceed against, you can initiate criminal proceedings against these entities. You are free to do that. And section 66 does not mean that you can't proceed against third parties. You can't initiate criminal action against that. So other parties can't say that because for these fraudulent transactions you have proceeded against the management, you can't proceed against us. So that plea can't be taken by them. Regulation, certified, preferential, or other transactions, I think we can ignore this para. The IBC specially empowers NCLT to consider application to declare certain transactions, namely preferential, undervalued, or extortionate credit transactions, as void, and to pass appropriate orders under section 44, 48, and 51. So see, there is a difference between other sections and 66. Section 66 is not a avoidance transaction, is not a section covering avoidance transaction, because power to avoid a transaction is not there with honorable adjudicating authority under section 66. But in the section 43, 45, etc., that powers are with the honorable adjudicating authority. Honorable adjudicating authority means pass an order that that particular item for selling of the assets at undervalued price is set aside, is declared as null and void, and honorable adjudicating authority can make the recovery from third party. So that is possible. Against third party, you can pass orders under section 43, 45, etc., but not under section 66. Such orders are aimed at reversing adverse effect by the concerned transactions inter alia, requiring the persons who benefit from any such transaction to pay back any gain he may have made as a result of the transaction if an application for avoidance of such transaction is made. Okay, so there's the difference between 43, 45, etc. with section 66. Other sections are avoidance transaction. In other sections, you can proceed against third parties. Directions can be given for avoidance of transaction, but not under section 66. and is made by a liquidator or RP under section 43 in case of preferential transaction, section 45 in case of undervalued transaction, section 50 in case of extortionate credit transactions, respectively. Then by a creditor, the application for avoidance can be made by a creditor. So there is another difference that under section 66, only RP or liquidator can make the application, but under other sections, in some sections, the other parties can also do that. Like under section 47, a creditor, member or partner of the corporate debtor can also file an application for avoidance transaction if RP does not do that. Okay. Further, IBC empowers NCLT to make an order under section 49 in case of transactions defrauding creditors in the interest of the victims of undervalued transactions referred to in section 45(2) of IBC. If it is established that such transaction was deliberately entered into by corporate debtor for defrauding creditors. IBC contains adequate measures to make appropriate application by liquidator or RP or by creditor or member or partner or corporate debtor for avoiding certain transaction under provisions of section 43, 45, 47 and 50. It is clear from the language of section 66(1) that unlike applications provided under section 43, 45, etc. for avoidance of such transactions and dehouse these provisions, an application contemplated exclusively under section 66(1) is not made for avoidance of any transaction. This is the finding of Honorable Adjudicating Authority. So that is the reason we call them avoidance transactions. 66 is not an avoidance transaction, even if fraudulent, but to fix the liabilities of the persons responsible for conducting the business of CD, which is fraudulent or wrongful, that to an application made by RP during the CIRP or a liquidation process. So application can be made by this one. Then in legislature wisdom and as apparent from the text of 66(1), it is clear. Firstly, it confers no jurisdiction for declaring any transaction. So this is the final part of the judgment. It confers no jurisdiction for declaring any transaction as void, even if fraudulent, but confers jurisdiction on NCLT to fix the liability on the person responsible for conducting business of CD which is fraudulent or wrongful. Then, secondly, section 66(1) contemplates an application thereunder only by the RP and by none other. Third, section 66(1) also restricts the power of NCLT subject to being satisfied with prerequisite that any business of the CD has been carried on with intent to defraud creditors of the CD or for any fraudulent purpose, and if it is satisfied, its power to pass an order is only against such person who are responsible for the conduct of such fraudulent business of the CD, with mens rea to make them personally liable to make such contribution to the assets of the CD as it may deem fit. There is no arbitrariness, matchless, manifest arbitrariness in section 66(1) of IBC to entertain the instant petition, to declare the said provisions as ultra vires of Article 14 and unconstitutional as alleged or otherwise. There is no merit in the submission of the petitioner, and the prayers made cannot be considered. With the above observations, this court has no hesitation to dismiss the present writ petition. Accordingly, the writ petition stands dismissed. So this writ petition was dismissed. There were no merits found by Honorable Tripura High Court in this. So this was the judgment. Now, there were certain judgments which were relied upon by Honorable. I think let's continue this, and then for the next judgment, I think we'll take a break. Huh? Okay. So these are the judgments which were relied upon while delivering this judgment by Honorable Tripura High Court. Judgments relied upon by Honorable Tripura High Court. One is Usha Ananta Subramaniam versus Union of India. Okay. So as I said, that already I have explained to you that in this particular matter, the issue which was decided by Honorable Supreme Court was that 339 subsection 1, the court's power is not to proceed against the third entities or their management. Okay, so on the basis of the same, this in Sudeepa judgment, Honorable Tripura High Court has held the same thing. So let's read this judgment, this relevant portion, which is reproduced in the judgment. In Sudeepa Das judgment, this portion has been reproduced. Section 337 of the Companies Act they are talking about refers to penalty for frauds by an officer of the company in which mismanagement has taken place. So Section 337 of Companies Act deals with the situation where mismanagement has taken place. Likewise, 339 refers to any business of the company which has been carried on with intent to defraud creditors of that company. Obviously, the persons referred to in Section 339(1) as persons who are other than the parties to the carrying on of the business in the manner aforesaid, which again refers to the business of the company which is being mismanaged and not to the business of any other company or other persons. Then, this being the case, it is clear that powers under these sections cannot possibly be utilized in order that a person who may be head of some other organization be robbed in and his or her assets be attached. This being the case, we set aside the impugned order passed by NCLT and as well as the NCLT. The appeal is allowed in the aforesaid terms. So under Section 339, because that winding up was going on under the provisions of Companies Act, so Section 339 was resorted to. The MD of a bank, the assets of the MD of a bank were attached, and then they were seeking orders from the adjudicating authority against these assets of the MD of that particular bank. But Honorable Supreme Court said in that matter, no, you are not having powers. Section 339 does not allow you to do that. If you want to proceed, you can proceed against them separately. You can initiate, if they were involved in the fraud, you initiate criminal action against them. Some money has been siphoned away, you initiate recovery action against them. But 339, you can't. Then we may clarify that nothing stated in this judgment will have any effect insofar as the investigation conducted by the CBI or the investigation by SFIO is concerned. Okay. Then there is another judgment, which is South India Paper Mills Private Limited versus Sri Rama Vilasam Press and Publication. So here also the order was passed and it was relied upon by this Sudeepa Nath judgment. And this judgment is of Honorable Kerala High Court. A relevant portion is, it will be useful to compare the provisions of Section 542 with those of Section 543 and 531. Section 543 empowers the court to assess damages against delinquent directors and others who occupy a fiduciary position in relation to a company. They are expected to act at all times in the interest of the company, eschewing fraud, underhand dealings, and motives of personal aggrandizement. They also owe a duty of care. If they are found to be in breach of the duties attached to their special position, they are liable in damages under Section 543, and the court can order them to make good the loss sustained by the company as a result of their conduct. Misfeasance proceedings under the section lies for breach of any duty, even if it does not amount to a perpetration of fraud. The thrust of Section 531, on the other hand, is against fraudulent preference, parting with the assets of the company in favor of a few creditors with a view to defeating the others. The court is given power under this section to invalidate such transfers made on the eve of winding up. So under 531, that power was there. The three sections are thus part of a scheme for reducing the liabilities of the company, recovering its assets, and recouping its losses if the conditions prescribed by them are found to exist on an examination of its affairs after winding up. While Section 542 seeks to relieve the company of the liabilities incurred by fraudulent trading, making those responsible for the fraud personally answerable, the purpose of Section 531 is to recover assets which should have belonged to the company but for fraudulent preference. Fraud is a common ingredient for both, whereas the proceedings under Section 543 are designed to reap losses sustained by a breach of duty, which may fall short of fraud. Okay, so 540T seeks to relieve the company of the liabilities incurred by fraudulent trading. So these three sections have been considered by in that particular judgment. Then this is another judgment of Honorable Calcutta High Court. The Honorable Calcutta High Court in this particular matter, Prashant Properties Limited versus SPS Steel Rolling Mills Limited, in the context of Section 66. Even if Section 66 of IBC applied to past transactions, unlike Section 44, 48, and 51 of IBC, under which the NCLT, as adjudicating authority, can avoid past transactions, under Section 66, the NCLT cannot avoid past transaction, even if fraudulent. But under Section 66(2) can only direct the directors, partners of the CD, and not other parties to the transaction to make contribution to the assets of the corporate debtor. So this was I think the same thing Honorable Calcutta High Court has said, that you can't avoid transaction under Section 66. Okay, and under Section 44, etc., you can do that, but not here under Section 66. It seems that Section 43 and 44, as well as Section 45 of IBC, are incapable to the present and applicable to the present case, in view of those being maintainable only at the instance of a liquidator or resolution professional. So here also the ratio was that NCLT cannot avoid past transaction under Section 66. So these were the three judgments. There were certain other judgments also. They relied upon even on JP Infra matter, but I think these were the three main judgments. I think let's take a break for 10 minutes and then we start. This is another judgment of Honorable Supreme Court. So this is earlier one was Honorable Tripura High Court, but this is Honorable Supreme Court on the same issue. Okay, it's a brief, but it's not a very big judgment. Okay, so I think let's break for 10 minutes and then after that we rejoin. Okay, so this is 3:26. So after 10 minutes, huh? Okay.
Shall we start, Anjali? Shall we start?
So let's start, huh?
Yes, you can proceed, sir.
So now this is another judgment of Honorable Supreme Court of India, which is Gluckrich Capital Private Limited, who is the appellant in this matter, versus the state of West Bengal and others. So this is judgment is dated 19th of May 2023. And this is on with respect to the same topic of section 66. Facts. The applicant filed an application. It's not a very big judgment. It's a very small, I think may not take more than 15-20 minutes. Applicant filed an application, Gluckrich. They filed an application seeking clarification of judgment and order dated 21st February 2023, passed by Honorable Supreme Court, wherein SLP number 6732 of 2023 filed by the applicant was dismissed. So there was another application. There was there was an SLP which was filed by the same applicant, Gluckrich, before Honorable Supreme Court, and Honorable Supreme Court dismissed that on 24th February 2023. The applicant, which is Gluckrich, GCPL, an unsecured creditor of Messrs. Leading Hotels Limited. Leading Hotels Limited was under insolvency CIRP process, which was facing insolvency proceedings under IBC. So Leading Hotels Limited, which is LHL, and then Gluckrich is the applicant, which is GCPL. Applicant filed the SLP challenging the order dated 30th 11/2022, passed by Honorable Delhi High Court in criminal MC number such and such, extending the transit anticipatory bail granted to the respondent, who were the suspended director of LHL. Okay, so applicant Gluckrich or GCPL challenged in the SLP. They challenged the order dated order dated 30th 11/2022, passed by Delhi High Court in criminal MC number such and such. As per that, in that the order of Honorable High Court, Delhi High Court, which was challenged, was extending the transit anticipatory bail granted to the director of LHL. So there was one director of LHL. He was granted anticipatory bail, and that anticipatory bail was extended by Delhi High Court. So this creditor, Gluckrich, challenged that before Honorable Supreme Court by filing SLP. Wide order dated 24th February 2023, that SLP was dismissed on the ground that the applicant had no locus in the matter, as he was neither. So he was a creditor. He was one of the creditors of the corporate debtor. So that SLP had been dismissed earlier. So wide order dated 24th February 2023, SLP was dismissed on the ground that applicant had no locus in the matter. As he was neither the informant nor a party to the proceedings before Delhi High Court, and was totally unconnected with the FIR lodged by the financial creditors, who were the members of COC. Okay, so against the promoter or against the directors of LHL, Leading Hotels Limited, there were some FIR lodged by the financial creditors, who were the members of COC. Okay, and in that FIR, there was some anticipatory bail, and which was extended by Honorable Delhi High Court. And this particular creditor, who was not there even in the COC, or he was not even the informant or not a party to the proceeding, he challenged that Delhi High Court order, wide which anticipatory bail was extended, or rather transit bail was extended. So that was challenged, and Honorable Supreme Court dismissed that, saying that you are not a party there. Applicant approached Honorable SC by filing this application seeking clarification of the above referred order dated 24th February 2023. So now, so this earlier SLP was dismissed. Now he is seeking clarification. So for that purpose, this particular application has been filed, and applicant says that your earlier order, which was which SLP was dismissed. So it said order dated 24th February 2023 dismiss the SLP. Maybe the order dated dismissing the SLP may be clarified to the effect that it shall not come in the way of the applicant persuading the RP to consider initiation of recovery proceedings under section 66 of IBC against the persons who prima facie appear to be primarily responsible for the fraudulent affairs of the CD, and also other persons and organizations with whom any business was carried out by the CD fraudulently and illegally with malified intention. So he said, ठीक है, you dismiss that earlier SLP, but kindly now clarify that your dismissal of earlier SLP does not mean that I cannot make further efforts. And what he said was that your order will not come in the way of applicant persuading RP. अगर मैं RP को जाके कहूं कि initiate recovery proceeding under section 66 against persons who are primarily responsible, that means against existing directors, and then against other persons and organizations with whom any business was carried out. So in a way, he was asking Honorable Supreme Court to clarify that third party, allow me, he said that आपने वो order pass कर दिया, but that does not restrict me from approaching RP and requesting RP that file application under 66, not only against the existing management, but against third parties also. But third parties, as per Sudeepa Nath, you can't proceed. Okay, so Sudeepa Nath said you can't proceed against the third party, and here this Lookridge Capital, they approached Supreme Court and said, sir, आप ये clarify कर दीजिए कि now I can approach RP and I can request RP that he can proceed under section 66 against the management as well as the third parties. It was further submitted that judgment, now he is coming to this judgment of Sudeepa Nath. He said, the judgment passed by Honorable Tripura High Court in Srimati Sudeepa Nath versus Union of India and others, wide order dated 18 January 23, had wrongly relied upon the judgment of Honorable Supreme Court in the case of Usha Ananta Subramaniam versus UI. So now he said, ki sab, theek hai. So one is that he is seeking clarification on his 24th February 23 order. But now he is raising some other issue. He is saying that in a way, he is challenging this Sudeepa Nath order. Sudeepa Nath order, he is challenging here before Honorable Supreme Court. He says that while passing Sudeepa Nath order, Honorable Tripura High Court has wrongly relied upon the judgment of Honorable Supreme Court in the case of Usha Ananta Subramaniam case. So as you are aware, as we discussed, that Usha Ananta Subramaniam case was where Honorable Supreme Court says that under the provisions of that 339, you can't proceed against the third parties. Okay, so he said, this person said that Tripura High Court has wrongly relied upon Usha Ananta Subramaniam case. Then the sentence is coming from there only. And the Tripura High Court has wrongly relied upon the judgment of Honorable SC in the case of Usha Ananta Subramaniam versus UI, and has erroneously held that section 66 of the IBC cannot be invoked against other persons, entities, or organizations with which there was any business transaction by the CD, but only the persons who are responsible for the conduct of the business of the CD can be proceeded against. So he said that Sudeepa Roy judgment is wrong. It has wrongly relied upon the Usha Ananta Subramaniam case, and based on Usha Ananta Subramaniam, this judgment says that under 66, RP cannot, or adjudicating authority cannot pass any order against third party. So it is wrong. So this was his contention. Honorable Supreme Court, in our considered opinion in the name of seeking a clarification, the endeavor of the applicant is to indirectly get over with the judgment and order dated 18 January 23, passed by Tripura High Court. Such an endeavor in the guise of a clarification cannot be permitted. So you are seeking clarification of the order which was passed in your case, and now why you are raising this issue of you are challenging another judgment through this clarification. So Honorable Supreme Court that said that no, it can't be permitted. Then we may observe that the Tripura High Court has rightly relied upon the observations made by this court in a binding precedent in Usha Ananta Subramaniam versus UI, which pertains to a matter under section 339(1) of Companies Act, which is pari materia with section 66 of IBC. So Anant Subramaniam is under section 339(1), which is at par, which is similar to section 66. So they have, the Tripura High Court has rightly relied upon that particular judgment. Okay, then we are of the considered opinion that in such circumstances, it is for the RP or the successful resolution applicant, as the case may be, to take such civil remedies against third parties for recovery of amount payable to corporate debtor, which may be available in law. The remedy against third party, however, is not available under section 66 of IBC, and the civil remedies which may be available in law are independent of the said section. So in this judgment, in view of the above fact and circumstances, the application for clarification is wholly misconceived and accordingly stands dismissed. So under this judgment, Honorable Supreme Court has upheld the judgment of Sudeepa Nath, and they have very clearly said here that 66, under section 66, you can't proceed against third parties, and the RP or the successful RA can proceed against those third parties in separate legal proceedings. They can initiate separate recovery action, they can initiate insolvency process against them, or any criminal proceedings also can be initiated. So this is the judgment of Honorable Supreme Court in Glukrich. So I think these two judgments today, they deal with this section 66(1). So this is now settled position of law that 66, under section 66, only the existing management or the management who was there, they or those people who are involved in this fraud, they can only be proceeded against from them only recovery can be made, not against third parties. Application under section 66 can be filed by only the RP or the liquidator, not by any creditor or any shareholder of the company. Okay, so this is the ratio, I think, of this judgment, and we have to, as RP, we have to act according to this judgment while filing application under section 66. Now, let's see any further judgment. So I think we can take up this rainbow paper, though already I think it's an old judgment. But still, and you are aware that Government of India is in the process of reversing the effect of this particular judgment. Though this particular session also, in this session also, I think that that bill has not been Yes.
Don't you think there is another judgment subsequent to the rainbow paper wherein the Supreme Court has partially nullified, that government dues wala become an,
No, they have not.
There has been a judgment because last time when we were talking of when there was a session by the ICSI, Mr. Makhija was referring that rainbow paper has been nullified, and I too read that judgment.
No.
That was 3 or 4 days after that judgment.
I think
so I'm not able to recollect the name of the judgment, but I too read it.
I'm aware there was a review filed of this particular, against this particular judgment. There was a review filed, and
Okay.
So there was a review filed, and there certain comments were made, but it is not that, which is in all the cases that is there in the review. What they have said is that they said certain things, but that is not having the effect of nullifying this thing.
No, but
Still,
do you think that pursuant to the rainbow paper now, the government dues?
yes,
Uh,
yes, yes. In all the cases, applications are being filed. In Delhi, we are having this this Noida authority. They are filing. Other authorities also,
I got
PF
the point,
authorities,
sir.
sales tax authorities. They are approaching the courts, and then I think this judgment is very much relevant as on today. Its effect has to be reversed by amending the law. There is an anomaly under section 53. An anomaly has been there, which has been highlighted by this judgment, and that anomaly has to be reversed by making an amendment. Okay, so I think I will elaborate on this. According to me, this judgment is right. There is nothing wrong in this judgment, except that there is one particular issue which I will be considering. Will discuss it with you, because at one place the judgment says that there is no contradiction under that law, that particular law and IBC. Okay, prima facie there is none, but there is one particular section, okay, where there is a contradiction. We will discuss that, which is not considered, but still let's discuss that. Okay, so very quickly we'll go through it. It is already, I think, 3:56, around 4 o'clock.
Yeah.
I think I have to complete the session by 4:30. I think within half an hour, very quickly we'll go through it. Okay, though I'm having some other judgments also, but I think today also this is very, very relevant, and I don't think its effect has been nullified. There was a review which was filed. That review was dismissed. People are wrongly interpreting that review, that its effect is reversed. I don't agree with the same. This judgment is very much in force as on today, and it acts as a precedent. Okay. So very quickly, so you are aware in this particular matter, what has happened is that certain dues were there of VAT authorities under Gujarat VAT Act, and Gujarat VAT Act said that if any dues are there under that act, so those will be there will be a charge over the assets of the CD. Okay, so they said that we are the secured creditor because there is a statutory charge created over the assets of the CD. Okay, and they said that section 53 says that secured creditor. It does not say secured financial creditor. Priority is there under section 53, and as per that priority, if I'm a secured creditor, whether operational or financial, I have to be treated at with that priority. I have to be treated under that particular clause of section 53, along with the workers' dues for the last 24 months. Okay, so that is the issue here. The issue is that whether a statutory charge is to be treated as a security, is to be treated as a charge under the provisions of IBC, whether a statutory charge. So as we are aware that how charge is created. So under section 52, if we see, I think let me see that section 50. Let's go through section 52. According to me, there is a contradiction with section 52. Okay, 1 minute.
Can I just interrupt you for a minute, sir?
Yeah.
I'm so sorry. The judgment I was referring to was Paschimi Anchal Vidyut Vitran Nigam Limited versus Raraman Ispat Private Limited. Thank you very much.
Yeah. Okay. We'll consider. Okay, actually, this was also challenged. You are aware that there was a review which was filed.
Yes.
52. So see, secured creditor in liquidation proceedings. Okay. Let's come to the point directly as to what is a secured creditor. Who is a secured creditor? I think subsection 3. Subsection 3. Section 52, subsection 3. Before any security interest is realized by the secured creditor under this section, the liquidator shall verify such security interest and permit the secured creditor to realize only such security interest, the existence of which may be proved either A, by the record of such security interest maintained by an IU, or by such other means as may be specified by the board. So security interest can be existence of a security interest as per section 52 of IBC can be proved by these two mechanisms, by these two methods. One, by the record of IU, information utility. If a charge is registered with information utility, then it is treated as a charge proved under IBC. Second is by such other means as may be specified by the board, and the board has specified that under regulation, I think 21 or 21, I think 21. I will read that. 21 of liquidation regulations. Yes, 21. Proving security interest. I will read it to you. Existence of a security interest may be proved by a secured creditor on the basis of A, the records available in an information utility, if any. B, certificate of registration of charge issued by the registrar of companies, or proof of registration of charge with the Central Registry of Securitization, which is CERSAI. So these are the three methods through which an existence of a charge can be proved. So which is pursuant to section 52 subsection 3. Subsection 3 says that one, from the record of IU, security interest can be proved, or by such other means as may be specified by the board. And board has specified that as per under section 21 of these liquidation regulations. Okay. So what board has specified is that two additional methods they have prescribed. One is certification of charge issued by ROC, and second is proof of registration of charge by CERSAI, which is Central Registry of Securitization, Asset Reconstruction and Security Interest of India. So these are the three methods through which you can prove that there is a charge. Now question is that if there is a statutory charge, that charge is not registered under any of these three, then whether that can be treated as a charge? Answer is no, because law says very clearly, if suppose I am an RP, somebody comes to me and says that I am having agreement with the corporate debtor, but I have not registered my charge with the ROC or any other authority, whether I will be treating him as a secured creditor? Answer is no. Reason is, there is another reason why there is a requirement for registration of these charges. Requirement is so that they act as public notice. So if suppose I want to deal with a company, so what will I do? I will go to registrar, or I will go to these two other authorities and will determine whether any charge is there on the assets of these companies, of that particular company. So if charge is not registered there, then I am entitled to assume that assets are not having, there is no charge over the assets of that particular entity. Okay, because these charges, registration of charges, they are treated as public notice. And if charge is not registered, I think we are having certain judgments also. If charge is not registered with earlier we were having ROC mainly, subsequently this CERSAI and this IU thing has come. So now any of these three authorities, if there is a registration, then only. But these charges which are there, which is a fourth kind of charge, which is called statutory charge. And statutory charges are that we are aware that many enactments, they provide that if any dues are there under a particular act, then that will be having a charge over the assets of the CD. So whether that charge is having the similar effect, answer is that if that is registered, then that definitely that can be. But in most of the cases we have seen, like this particular GVAT Act, under that GVAT Act, there was no charge which was registered. Under, I think, these are the charges like Noida Authority and other authorities, whether they have got their charges registered, answer is no. Okay, so these are statutory charges which are being claimed by them. And yes, let us come back to our, sorry. Let me share the PPT again. Okay. So we were on this. So in this particular matter, the government, the sales tax authorities or the VAT authorities, they were having this claim. Can you see it on your screen? No.
No, sir, we can't see.
Okay. 1 minute. Hope you can see it now. Yes.
Yes, sir, yes.
Yeah. So this, so because of this provision under law, and most of the, and you are aware that before this law came, before IBC came, the lot of confusion was there. Secured creditors who were bankers, they were claiming themselves to be the secured because their charges were registered. But most of the cases, state governments, they were claiming their dues like sales tax. Different state governments, they were having different sales tax law, and they were claiming their dues as secured. So bankers, they were not getting anything. They said that we are having our statutory charges is superior than the charge which the lenders are having. So our charge is statutory charge. Okay, so PF authorities, they were claiming, excise, taxation authorities, income tax authorities, all of them, they were claiming that their charge will be, they will be secured creditors. And in order to sort out this issue, under this law, you must have seen that under IBC, the preamble says that the priority of government dues is being altered through this law. And for that reason, and this was a conscious decision which was taken, reason for the same is that in most of the cases where heavy statutory dues were there, in most of the cases, these statutory dues were being created, companies were not in operation, ex-parte orders were being passed, heavy interest and penalties were being imposed, so huge dues were there. And these secured lenders like bankers, etc., they were not getting anything. If company is liquidated or company is revived, so then revival is not possible only because the entire money was going into the pocket of these statutory creditors. So this conscious decision was taken that if you have to revive these companies, then government's priority has to be reduced, and the financial institutions, banks, etc., if they are having secured dues, then they have to be the contractual dues. They are called contractually, they are secured. Okay, so these secured dues, they have been recognized under IBC, and they have been given priority in distribution of realization of assets of the CD in the case of liquidation. And statutory creditors, all statutory creditors, they are much lower in priority. Okay, so this particular issue, Honorable Supreme Court in this particular matter said all these pleas were taken, that there is the plea which was taken was that there is a contradiction, because preamble says that government's dues, they are not having the priority. The priority has to be the secured creditors who are contractual secured creditors. But Honorable Supreme Court said no, because the word which is used under section 53(1) is that secured creditor. It does not say secured financial creditor. So even an operational creditor who is secured, he will also fall in this category and has to be dealt as per this this revised schedule 53, or this section 53. Okay, so now because of this anomaly has been, the government wanted to reduce the priority of government dues, but still the language which has been used is the word which has been used under section 53(1) is secured creditors, along with the 24 months dues of the workers preceding the ICD. They will be having, after liquidation cost and after CIRP cost, they will be having the first priority. Okay, so but that was not the intention. Intention was that all kinds of statutory charges, they have to be disregarded. But because of this anomaly which has been there, I think now the government is in the process of resolving this, because otherwise no plan will be approved. All the plans which are there, if any statutory creditors are there and they are having a statutory charge as per their law, then in that case you will have to treat them at par with the secured bankers. And in that case, I think bankers may not give their consent for approval. So that difficulty will be there. So because of which now, and I have pointed out this thing, that section 52, this particular, now if we see, there is a contradiction in this laws, because this plea was taken earlier also, but I have not seen in this judgment that section 52(3) has been referred to for the purpose of identifying that the law, GVAT law, Gujarat VAT Act, and IBC, they are having this contradiction, because IBC says that only in that situation where a charge is registered in a particular manner, only then it will be treated as a security interest, otherwise not. But GVAT Act says that there will be a charge over the assets of all corporate debtors where any GVAT dues are there. So there is a contradiction, and based on that contradiction, okay, the IBC section 238 says that it will be overriding the provisions of all other laws. So if we consider that, then in that case, I think in that case, the GVAT dues may not be treated as secured dues and will have to be treated at much lower priority. So this is that particular judgment. A number of other things have also been said in this judgment, with which I think most of us will not be agreeing. This judgment says that if government dues are there, then even if they don't file their claim, still you have to make provision for the same. So I think which is totally contrary to the provisions of IBC, which says that yes, claim has to be filed, and a number of judgments are there. Mr. Ghanshyam, what is that judgment? Ghanshyam something. So that judgment says that if claim is not filed, okay, then the relevant parties, they can't claim any dues from the corporate debtor. Then SR judgment is there. A number of other judgments are there which say that if claim has not been filed, then those parties cannot claim those that get extinguished. Okay, so these type of findings which are there, I think there are other judgments which I think having a different view. So I think I don't agree with those particular findings here, which say that the even if these authorities, they don't file, still you have to consider them in the resolution plan. You have to treat them at par and all that. I don't agree with the same. So I think this is this particular judgment. And I think last judgment portion. Let's go through this one, huh? This is the most. Learned Solicitor General rightly argued that when a grievance was made before adjudicating authority with regard to a resolution plan, adjudicating authority was required to examine if the resolution plan met the requirement of section 30 subsection 2 of IBC. The word satisfied used in section 31(1) contemplates a duty on the adjudicating authority to examine the resolution plan. The resolution plan cannot be approved by way of an empty formality. And Honorable Supreme Court in this particular matter was of the view that because the dues of the provisions of Gujarat VAT Act were not complied with. So this law, this particular plan, which was approved by the adjudicating authority, that did not comply with the provisions of law, that did not comply with the requirement of section 30 subsection 2 clause E, which requires that it should comply with resolution plan, should comply with all the requirements of all law which are in force for the time being. As rightly argued by the learned Solicitor General, there can be no question of acceptance of a resolution plan that is not in conformity with the statutory provisions of section 31(2) of IBC. Section 32(b) of IBC cast an obligation on the RP to examine each resolution plan received by him and to confirm that such resolution plan provides for the payment of dues of operational creditors as specified by the board, which shall not be less than the amount to be paid to such creditors in the event of liquidation of the CD under section 53, or the amount that would have been paid to such OC if the amount to be distributed under the resolution plan had been distributed in accordance with the order of priority in subsection 2 of section 53, whichever was higher, and provided for the payment of debts of financial creditor who did not vote in favor of the resolution plan in such manner as might be specified by the board. Under section 31, the IPC of the IBC, a resolution plan as approved by the COC under subsection 4 of 30 might be approved by the adjudicating authority only if the A is satisfied that the resolution plan is in compliance with section 32E. The condition precedent for approval of a resolution plan is that resolution plan should meet the requirement of subsection 2 of section 30 of IBC. And in terms of regulation 39(4), RP shall endeavor to submit the resolution plan approved by the COC before adjudicating authority for its approval under section 31 of IBC at least 15 days. I think we can skip certain things. A resolution plan which does not meet the requirement of subsection 2 of section 30 of the IBC would be invalid and not binding on the central government, state government, any statutory or other authority, any financial creditor or other creditor, or to whom a debt in respect of dues arising under the law for the time being in force is owed. Such a resolution plan would not bind the state when there are outstanding statutory dues of a corporate total. In our considered view, the NCLT clearly aired in its observation that section 53 of IBC overrides section 48 of GVAT Act. Section 53 of IBC begins with a non-obstante clause which reads. So this is correct. Honorable Supreme Court says that the NCLT says that section 53 overrides GVAT Act. But that was not the case. 53 did not say 53 was not contrary to GVAT Act. Rather, 53 dealt with these secured creditors, and GVAT Act says that secured creditors, government dues will be treated as secured. So there was no contradiction. Section 48 of GVAT Act is not contrary to or inconsistent with Section 53 or any other provisions of IBC. Under Section 53 1B2, the debt owed to a secured creditor, which would include the state under the GVAT Act, are to rank equally with other specified debts, including debts on account of workmen's dues for a period of 24 months preceding the liquidation commencement date. So actually there was no contradiction or there was no inconsistency between GVAT Act and Section 50. As observed above, the state is a secured creditor under GVAT Act. Section 330 of IBC defines secured creditor to mean a creditor in favor of whom security interest is created. Such security interest should be created by operation of law, could be created by operation of law. The definition of secured creditor in the IPC does not exclude any government or governmental authority. So this was this particular judgment. And the judgment which you are seeing, I have not actually completely gone through the same. But according to me, this particular judgment is right. Only thing is that there is a anomaly. It is right interpretation which, so far as this particular issue is concerned, as to whether GVAT Act should be considered, as to whether the dues under GVAT Act should be considered as secured or not. So, or should fall within the definition of secured creditor. To that extent, it is right, except that Section 52, subsection 3 has not been considered while delivering this judgment. Okay, so they say that there is no contradiction, but I think this needs to be rectified. This issue has to be, through an amendment only it has to be done, and I'm sure that it will be done. Otherwise, all these resolution plans, I think it will be difficult, because all the authorities now, they are claiming themselves to be secured creditors, and we are not having any answer to that, except that now 52(3) thing can be claimed. I am having this, but I don't think Jet Airways Maintenance Engineer Welfare Association versus us. It's also a recent judgment, but I don't think I am having sufficient time. So with this, we can close today's session, except that if you are having any question relating to those two or three judgments which we have considered today, we can discuss that. Otherwise, we can close today's session. Any questions? Yeah, Mr. Rana.
No, sir, no questions.
There is no question. Okay. So shall we close? Anjali, are you there?
Sir, I'm reading.
Yeah.
Since I didn't have the judgment, I'm just reading it from the net. What it says is that in particular that judgment of Pashchimi Anchal Vidyut Vitran Nigam Limited versus Raman Ispat.
Right.
I may not be able to delve to the extent that you can, but what it says is that Supreme Court in that particular judgment has confined the applicability of STO versus Rainbow Paper to its own factual circumstances, effectively quarantining Rainbow Paper from the jurisprudence on treatment of government dues under the code and allied regulations. I read the judgment in detail. You know, the judgment speaks about the best practices on treatment of the operational creditor dues on a global basis. And as such, it delivered this particular stuff that insofar as the Rainbow Paper was concerned, it was circumstances which were peculiar to that particular. Yes, you are absolutely right that, you know, when a leeway is given to somebody, when I say somebody, mean to say some class of creditor, they will lap onto it, and using that bait, they can claim their dues to be sort of the statutory dues to be the secured one. But I think this judgment came a month or even
Yeah, very few,
earlier
yes.
than that. So I read that judgment. I read that complete judgment, wherein they have specifically said that you leave that rainbow denim. That is confined. That's a
Is
unique
that
piece of it.
Supreme Court? Is it a Supreme Court judgment?
Yes, sir. It is a Supreme Court. I'll just a minute. This is uh, Pu- Purvanchal.
Yeah, I'm aware that, yes, but I have not
Yeah,
gone through the same.
Pashchimanchal Vidyut Vitran Nigam Limited versus Raman Ispat
Raman Ispat.
2023. 2023 SCC online SC 842.
आजा आजा
That
हो
is the
गया
citation.
Okay, Mr. Hemant
That is the
Sharma.
citation.
Okay,
Yes,
okay,
sir.
okay.
Sir, I'm
That is the
audible.
citation.
Yes, you are right, audible. Yes,
Sir, I'm audible.
yes, Mr.
Sir,
Hemant.
my question is this: now the rainbow judgment, sir, this rainbow judgment has passed by the Supreme Court, and there are some resolution plans are pending in the before the NCLT. So in some cases, NCLT is asking to file an affidavit with respect to the statutory dues of the authorities, whether any sale tax, VAT, GST, with respect to that, what treatment you are giving in the plan. If you have not given any treatment as a secured creditor to them, so then they said you have to revise your plan. And if this judgment is not applicable because of now the whole you have summarized in your this presentation, so how can we deal in these situations practically?
Okay, okay. So Hemantji, this particular judgment of Raman Ispat has come recently. Okay, we need to go through that, and we have to see that as to what is the effect of the same, whether it is totally reversing the effect. Though actually the earlier judgment of Rainbow Ispat is interpreting the provisions of law, and as per their interpretation, the statutory charge has to be recognized. And they say the language, it is all of us know that section 53 uses the word secured creditors. Okay, so it does not say that only secured financial creditors can be secured creditors. If suppose some operational creditor is having charge, will he not be a secured creditor? I think under law we can't change this situation. Secured means secured, whether operational or financial. But the government policy was that when this enactment came, the intent of legislature was that the statutory creditors, they are not to be treated as secured. Their priority was reduced. Knowingly, their priority was reduced. But law, because preamble, when words are very clear, when words very clearly say that secured creditors, the word which is used is secured creditor, and that GVAT Act says that they will be treated as secured creditors. If VAT dues are there, payable to government of Gujarat, then they will be treated as secured creditor. So I think they will have to fall within this definition of secured creditor. They will have to be treated as secured under this law unless there is an amendment. So as I said that there is anomaly. Another thing is that section 52 subsection 3, it appears that it has escaped attention because according to me, it was not pointed out by someone. Otherwise, we see if we consider 52.3 says that a debt can be considered secured only when there is a charge registered in any of these three modes which are prescribed. But I don't think GVAT dues were secured, were registered with any of these authorities. So I think that is to be seen. And this plea we can take in suppose other in all the other matters, we can take this plea that if their dues are not registered, if their charge is not registered with any of these authorities, then they can't be treated as a secured creditor. I think that plea is the only thing which is possible now. Otherwise, we'll have to wait for the government to amend the law, for the parliament to amend the law, and then only. Otherwise, there is a genuine difficulty that in all the cases, these authorities, they will be claiming themselves to be the secured creditor, and then adjudicating authorities, they will have to treat them as secured creditor. Though it is subject to this new judgment which is come of Raman Ispat. So Raman Ispat, how they are on, what is the justification they are making? I think we have to, I have to go through and then only I can.
Yeah, according to me, sir, this IBBI also has to take care, like you rightly said, so that government has to amend the law so that this anomaly can be removed from this. Because
Yes.
in one of the cases, resolution plan has been pending since 2 years long, and now I received a letter from the sale tax authority that we are having a first charge on the same.
Yes.
So therefore, you cannot.
So genuine difficulty has been there, and in all the cases, these authorities like Noida Authority, Greater Noida authorities, in one of the matter where I am resolution professional, even in that matter, Greater Noida Authority, they have filed an application now. They say that we are secured because our law says that our dues will be treated as will be having a charge over the assets of the company. So this problem will be there, though all of us, if
I think that issue is in Supreme Court, sir.
no, if no, that matter. Yes, Noida authorities matters are there in Supreme Court also. Supreme Court also, certain appeals are pending, so
Right.
that is to be decided. But this particular issue, I think Paschim Vidyut, whatever that company is, let's see that if there is something which can be used by all of us.
One small query. Suppose you appointed as an IRP in the new matter, and you received a claim from the authorities like PF, ESI, and sale tax and all, and you are verified the claim. So can we treat them as a secured creditor, sir? Because they are filing their claim now instead of Form B to instead of Form C nowadays.
Okay. So now we have to consider these judgments. One is that rainbow paper, another is this Paschim Vidyanchal. We have based on the same, and third thing is that these charges are not registered. So presently we are following what we do.
Of law.
So
due to operation of law, they are treated as themselves as secured, and they are filing their claim under Form C, right?
Correct.
Nowadays.
Operational of law. They are saying that statutory charge is there, but IBC does not recognize that as charge unless the same is registered with any of these three authorities. Okay.
Then answer is that we have to treat them as an operational creditor.
Mr. Sharma, I think Mr. Sikdar is there. He is asking.
Nilesh, I would like to say one thing. One circular has been issued by GST department, circular number 187 in the month of December 22, where they have clarified that all the claims of GST will be considered as operational claim only, operational debt only, and everyone should file considering the same before the IRP, RP, or the liquidator, as the case may be.
Okay, they are not treating themselves as secured.
They have not used the word secured, but they have termed this as an operational debt only, has to be considered on that way.
No doubt. There is no doubt about the fact that, like Noida Authority dues Supreme Court judgment has been there, wherein clearly it is held that their dues are of the nature of operational debt. But operational debts can also be secured.
Secured, I understand. But in their circular, which has come only in the December 22, much later than the Rainbow judgment, etc., but they have not referred the word secured anywhere in the circular.
Okay. No, is there any clause in the GST Act which says that their dues will be treated as secured? Under GST law, I'm not sure whether any provision is there which says that any dues, like Income Tax Act also, I think income tax authorities, they are not treating themselves as secured. Because there is no section there which says that there will be a charge on the assets of the company. Okay, so I'm not sure whether GST law
it is there. It is already there, sir.
If it is there, okay.
It is there, but they are not claiming to be secured.
Okay.
But this circular has been has clarified the situation, I hope.
No, but that is only there, Sikdarji, that will be applicable only with respect to the dues of GST department. But there are other departments also. Okay, so they will still be treating themselves as secured, and they should do that, because if they are having that plea and there is a Supreme Court judgment in their favor, then definitely they will be claiming themselves to be the secured creditor.
So it makes the task of the RPs difficult, sir. If RP entered their claim as a unsecured, then they will file an application, and we have to be present before the court and explain.
You have to follow the law. If they become secured, you have to treat them as secured.
What is your practical experience in this, where the charge is not registered with the ROC, and whether that amount can be come under the secured?
Deepak ji, what we have been doing is that we don't treat them as secured if charge is not registered with any of these three authorities. Because section 52, it is not that only regulation is there. It is law which is saying, section 52 says very clearly. Section 52 read with regulation 21. It says that it has to be registered with any of these three authorities. If it is not,
Sir, that is applicable in the liquidation cases, not in the CIRP, sir.
nahin. So CIRP, we are under CIRP, we have to give them the treatment that in case of liquidation, how much value they will be, value they will be getting. So actually, while determining their liquidation value, you will treat them as secured or unsecured based on section 52 only, na?
Right.
Right? Okay.
Thank
Anything further? No?
Thank you, sir. Thank
Okay,
you. Thank
ji,
you to
okay.
enlighten us. Thank you
Thank
so
you.
much, sir.
Thank you.
Thank
Thank you. Thank you.
Thank you, sir.
Right. With this, we close. Anjali?
Thank you so much, sir. The session was very informative. Thank you for giving us your time and taking such a nice session.
Okay. Thank you very much, ICSI and all the participants. Thank you.
Anjali ji, please allow CPRs to all the participants.
हेमंत जी वो तो है ही ना आपने अटेंड किया है ना
अच्छा ठीक है दीपक जी ओके
थैंक यू नीलेश जी थैंक यू सर
थैंक यू
And